Welcome to Women Winning Divorce. I am your host, Heather Quick. I am an attorney, entrepreneur, author, and founder of Florida Women's Law Group, the only divorce firm for women by women. I love thinking big, thinking outside the box, creating creative solutions for women, and empowering women to win in all aspects of their life. Our approach at Florida Women's Law Group is to provide women with a strategy to not only achieve their objectives, but win at life. I believe that what may show up as adversity is simply an opportunity to change and improve your life. In each episode, I sit down with innovative professionals and leaders who are focused on how you can be your best self before, during, and after divorce. In these conversations, we are looking at how women can win at life. I have the unique opportunity to meet women when they are at a transition period of life. But that is only the beginning to becoming your best self and winning at life on your terms. With our guests, we enjoy the opportunity to explore ways all women can win and enhance their life, no matter where they are in their journey. Because divorce is just a point in life, not the end and not what defines you, rather a catalyst for your growth. Welcome to this week's episode of Women Winning Divorce. I'm Heather Quick, owner and attorney at Florida Women's Law Group. Today, I'm joined by Alyssa Honickman to answer for our listeners, what is a modification? Alyssa is the owner of the law offices of Alyssa D Honickman down in South Florida, so not too far from here, with offices in Boca Raton and Fort Lauderdale. So welcome.
Thank you so much. I'm happy to be here.
Well, we are excited to have you. I really love having attorneys as guests, of course, and even better, an attorney here in Florida. So it's just great. And I am excited, of course, to talk with our listeners about, what is a modification? So we're so happy to have you on today and would love to know a little bit more for our listeners about you, professionally and how you got to where you are.
Not a problem answering those questions. So I actually grew up in Ocala. And I made my way up a little bit farther north, closer to you guys at University of Florida for undergrad. And then after that, I went to law school at Stetson in St. Pete. And I did an internship in the summertime while I was in law school at the state attorney's office down here in Broward in the 17th Judicial Circuit. Made a lot of really amazing contacts, got to watch some really cool trials. And I decided criminal law is where I want to be. So I'm going to jump into that. So I started my career, we call ourselves baby lawyers at the time, at the Broward County State Attorney's Office, where I can honestly say I made my closest lawyer friends who are dear friends of mine, even to this day. Most of us that I started with, it was almost like, just a little fraternity group and, co-ed, of course, women and men. And we've all been able to maintain really successful practices as sole practitioners. And what I always tell anyone, when they're first starting their career as an attorney, even interns, because I always offer summer internships available at my office, really the best way to get trial experience and learn about the court system and meet attorneys, meet judges, really just network and build your foundational litigation skills is really either at the state attorney's office or the public defender's office. So I stayed there for little over 4 years. And I slowly made my way into family law, which I know is what we're here to talk about today. But I will tell you the bridge for me was I ended my career as a prosecutor in the domestic violence division. I was one of their supervising attorneys, which meant that not only did I try some of the more complicated domestic violence cases, but I was in charge of training new lawyers that came into our division to really understand what domestic violence is, understand from the victim side, and then, of course, figure out, do we have enough evidence to prove our case? So when I started really that supervisor role, what I ended up doing is I followed my victims to whatever family court that they had going on. And I sat in the back, literally with a notepad, and I took notes. And now most of these domestic violence proceedings are closed and they're not open to the public. But back in 2007 and 2008, I was a prosecutor, so this was not my client. Obviously, I represented the state of Florida, but the victims were able to consent if they wanted me there. So I was able to follow them through their restraining order cases, through their, family law matters, whether it was a divorce or a paternity action. And I saw some really interesting things. I definitely saw a real large gap in how women were treated in court. And then, of course, we always get a little bit of an idea of what kind of lawyers we're dealing with in these different divisions. South Florida, I don't think, is any different than probably North Florida. The attorneys represent their cases in a way that they think is best, but it's not always the best way. And it opened up my mind to a lot of different avenues, and I decided I'm going to leave. I made some great friends, and then I opened up my own practice in 2010, and I started doing criminal defense work because that was my bread and butter. That's basically what I knew, with my eyes closed, my hands tied behind my back. And I did a little bit of criminal defense, and then I slowly made my way into family law. And now my practice is solely family law. I don't touch any other areas.
Well, I love that. And I love your story. And it's very similar to mine, which I don't know if you know that
Really?
or not. I graduated from Stetson College of Law, and I worked at the prosecutor's office in St. Pete, Clearwater, before transferring to back up to Jacksonville, where I'm from, and then embarking in family law after trying out a few other things first. But yeah, so that is a great story, and clearly you have stayed in family law, right? So many people try it and they're like, it's not for me. But there are some of us who just know we're lifers in it and we really like it. So, what is it about family law that really just keeps you there?
That's a good question. I thought about that in preparation for today, and I actually think about it a lot because some of our cases as family law attorneys are very hard. They're difficult, they're emotional, they're complicated. And, I always feel like it's our job to guide our clients. And once you understand the person, you can guide them into the law, and really help them understand how their facts will fit the law and how do we get the best outcome. So the reason I think I stayed in this area is I really liked family law because I felt there wasn't a lot of attorneys that understood evidence and didn't really understand what evidence can I use in this case? And most importantly, is it even admissible? Sometimes clients come in with stacks and stacks of text messages and photos, and it's like, this is great stuff, but is it admissible? Can we admit this into court? So the first part was I had a strong background in evidence, working at the state attorney's office. That was our job. Outline your case in advance, make sure you can prove it. You don't look like a fool in front of the jury. Let's get our stuff in order. But then the other part of it was I became a mom. And my first daughter was born in 2013. She's, gosh, almost 11. And then I had another daughter after that, and she's 7. She thinks she's 25, but she's 7. And once I became a mom and I had to deal with, just juggling everything, being a mom, running a business, being a great wife, being a good mom, being a great lawyer, I think it just strengthened my approach with my clients to help them. What I always say, and I know it sounds cliche when you say it out loud, but see the forest through the trees. I always wanted them to see, I know this is a really big problem right now, but how does this affect you moving on? Is this really that big of a deal that we need to spend hours and hours and tons of money? And some clients, they just want to, not all of them, but some of them they want to litigate, they want to fight, they want to win. But meanwhile, they're liquidating their Florida prepaid account, for their children. That those kids need that, for their college education. And so I felt there was a real gap in the system and understanding really how to connect with people. And I represent women and men. And sometimes the men needed a little more. What's the point here? What are we doing? And I felt a parental approach from what I was dealing with day to day. And then mixed with my evidentiary background and my love of litigating, which sounds silly, but I actually do like to be in the courtroom. It was a good mix. So it helped me stay and kind of get my roots into the system. And ultimately, I want to make money because I'm a business owner, right? We all want to make money and pay our bills, but I also want to help people. And I want to help people understand what are the main issues and how can we stop all of this poison from being, exploding out of yourself in the court system, and how can we make your life better?
I love that. And, I think there are so many of us who have very similar experiences to yours. And those are, for our listener, those are the attorneys you want to pick. Like, you should ask why they are doing family law, because I have found that the best ones, even to go against whatever, they just really care. It's more than this is just my job, because they care what happens to our listeners. And really, it's like you want your client just to be better off, right? And to get
Mm.
through the process and hopefully help them make better decisions that are looking at the long term, like you said, the forest through the trees, not just this issue today, but let's put it in perspective for your life and your children's. Is it
Mhm.
worth that much fighting and money? Will it really matter to you in 3 years?
Yeah,
Sometimes the
that's
answer is no, right?
no, sometimes it is. And you want to be able to stop that right there and say, well, maybe we should take a different approach. Or maybe this issue that's so important to you right now is not something you should be focusing on and spending thousands and thousands of dollars spinning your wheels when the outcome can probably be resolved sometimes, not all the time, with a
Mhm.
5-minute phone call to a reasonable attorney that can sit down with their client and say, this is the problem. How do we fix it? 1, 2, 3, right?
Exactly, exactly. So we just need to, everyone needs to listen to us, I think, Alyssa, because it sounds like we know what we're doing, right? Let's be reasonable. It
Exactly.
doesn't always work that way. And in some of those cases, what are about what we're going to talk today, but what are for I'd love for you to let our listeners know, talk about, what is a modification and what types of things can you modify? Because if I've heard it once, I've heard it a million times. Oh, well, I just figured I'd come back later and change this. And as we know, it's not quite that simple.
No, exactly. And it's an interesting topic to talk about in light of the fact that we have new law, on the issue of modifications, new law on time sharing, new law on alimony. And in Florida, July 1st, 2023 was a big change. It was a change for attorneys, it was a change for clients. And then there's this issue of, retroactive applications to the law and how does it affect your case if your order, which we call, final judgments, was actually signed before the law went into effect. Well, can we just run back into court and change it now? Because this is the new law. So with modifications, the new statute says you have to have a substantial and material change in circumstances. That's Florida Statute 61.13. And what's interesting is they took away the word anticipated, which I personally like that word. I thought it was important. I also thought it speared a little bit of some of the litigation with modifications because anticipation is something that I believe should be contemplated when you enter into an agreement because everybody's going to grow. Your kids are going to get older. We all know that. And your situation may change. But if you know of an anticipated event that's about to occur, it may change your perspective on what you're going to sign in the black and white writing today. But
Hmm.
that has gone away. That has sailed away, right? So now we have substantial change in circumstances, and it has to be a material change, and it has to be in the best interest of the children. So to focus on the children's issues, which I think is what you wanted to kind of focus on today, obviously alimony has changed a lot. There's probably a whole nother hours and hours of time for that. But if we just focus on the children's issues, what's most important is substantial. So if you just look up the dictionary, substantial does not mean I changed my mind. Substantial doesn't mean, well, it's different now. Well, things are going to be different because most people get divorced for a reason. And when you start your next chapter, whether you were married and getting a divorce or you're separating from your child's father or mother, you're going to have different situations, right? Things are going to be different for you. So substantial means it has to really affect what's going on. It has to have a substantial effect on what you're doing. And one of the, I think, easiest ways to explain substantial and material, which unfortunately our circuit courts don't necessarily agree with me on this. They're all over the place depending on where you live in Florida. But, you think about children, right? They're in elementary school now. Let's just take preschool versus kindergarten, right? You're in preschool and I think most places in the state of Florida, I don't live in Jacksonville, but I'm sure you'll correct me if I'm wrong. Your preschool bill for your kid is going to be a little higher than what you may pay for aftercare when your kid starts kindergarten. And if you're a working mom like me, you need aftercare. It's really important. It's important for lots of reasons. And so when we think about that, well, is it substantial and material? well, they're in preschool now and maybe their hours are a specific time, but the financial responsibilities related to how you're going to split up daycare expenses and preschool expenses are going to be dramatically different once your kid starts kindergarten. So I always tell clients, just as a practical matter, if your kid's 2, 3, 4, let's think about in the parenting plan what you would like to see happen when they start elementary school. So you're not calling me a year or two from now and saying, well, we need to file for a modification. Well, sure, you can, because it is a substantial change in circumstances, depending on the income, right? And depending on what
Right.
the expenses are, because I know different regions, school can be different prices. But let's think about that now so that you don't have to call me in a year or two from now and we have to basically reopen financials and restart discovery and start this awful situation all over again. And you're going to be paying more money. Let's not talk
Mhm.
about, let's not forget about that part. So substantial and material. And then we think about the best interest of the children. Whatever the changes that you want to make, you need to be able to establish it's not good for you, it's good for your kids.
Mhm.
And I think it's hard for a lot of clients when, sometimes there's a change in your job, or I know we talked a little bit about relocation and you have to relocate to another city and you can't honor the same time sharing schedule. If, for instance, you live in Fort Lauderdale and you got a job opportunity in Jacksonville, well, you're not doing weekly time sharing with the other parent. It's not happening. It's not going to
Mhm.
happen. Weekends, sure. Maybe not every weekend because that's a little bit of a drive, but your weekly schedule, your 2-2-5, Monday, Tuesday, mom, Wednesday, Thursday, dad, alternate weekends, that's not happening. So I always try to tell clients if you're calling me and you want to modify what's already in a court order, let's outline the reasons. Let's talk about it. Let's figure out, is this a good reason for you? And I have this little Excel spreadsheet where I have them color coded and we write it out together. Is this go in the parent column? It's good for me, or the kid column? It's good for your kid. And
Mhm.
sometimes just seeing it on paper, it's like, wow, this is not, I don't want to take this to court, or maybe we should, but just to see
Right.
it, get those thoughts out of your head and get them on paper so that you can really make a good, rational decision. Do I want to move forward with this or not?
Yeah, and I think that is part of the evaluation, which, for individuals and listening, it's wise to speak to an attorney, certainly rather than even just filing it yourself. Like, understand from an attorney, okay, what your chances are and what is it that you have to prove. Because I think we've both been in that situation where our clients definitely think it's substantial, or they think it's in the best interest of their child or children. Maybe it hasn't been substantial. And so there's just so many things that you really need that consideration and evaluation to help you understand how how likely, like, do we think it's enough to meet that burden? And then I think also is, what is it they're seeking, right?
Oh, yes,
Because
exactly.
that's the big thing. It's like, well, what is it you're hoping to get out of this? Because I think as an attorney, we have to ask that question so then we can determine, is that a realistic expectation, um, given this change you're wanting to make, particularly with time sharing, because I mean, those can be pretty complicated. And again, difficult, whether it's one party seeking more time or another seeking, I guess you're either seeking more time, which is equal to less time for the other parent. I think that, like,
Right.
that's generally why you're going to court. And then, of course, that does affect the child support. It just will automatically. And, we do a good bit of these. I have found often we see a lot of clients, whether or not we then feel like they have enough to move forward, but they really did their own divorce, their own parenting plan.
Yep.
And just like, well, I just want to get it done. I just wanted to get it, and we're really, in agreement. And then now they're coming to us and they want to change a 50-50, for example, which, up here in Northeast Florida before this statute change, it would depend on the judge. It was so common, but not every case, right? It wasn't all the time.
Right. Sure.
But now, and now with the statute changing and then you want to change it, I mean, I found there's a lot of evidence that you're going to really have to bring forth
to
Sure.
show that what is
Hmm.
currently going on is not in their best interest and that there
Right.
has been a change that's caused it to not be in their best interest.
No, absolutely. And I think the concept of what 50-50 means, sometimes people want it because they just want that equal time. But practically speaking, does it work for you? Does it work with your schedule? Is it best for your children? With small children, I generally don't like to recommend, and I'm saying generally, obviously, there's cases that don't fit the bill, but back and forth so much, parent to parent in the same week. It's so hard for a little kid to put their head down 2 nights, one house, 2 nights, the next house. And then, those kids that have an extra bag packed on the weekend when they get dropped off at school for the other parent's weekend time, how that kid feels when they're at school, knowing that they have to have that extra bag, ready to go because they don't know if they're going to have their special stuff at the other parent's house, or God forbid, the other parent doesn't drop off their stuff when they're supposed to, at the other parent's house. So this back and forth, I firmly believe in the statute that both parents should be equally fit to parent their kids 50% of the time. But let's tie the facts in your case to the law. What's going on in your life? What does your weekly schedule look like? And I don't know about in Jacksonville, but down in South Florida, if you live in Miami, for instance, and your kid is going to school, let's say in Fort Lauderdale, it's, at a private school in Fort Lauderdale or maybe a charter school, or maybe the other parent lives in Fort Lauderdale and they have the school designation. Just that drive in rush hour from Miami to Fort Lauderdale, sometimes it's an hour and a half in bumper to bumper traffic. And then you think about, well, you don't want to be that parent that's rushing on the highway to get to aftercare to pick up their kid at the right time. That's not the best thing for your kid because you're stressed, you're driving in traffic. And then when you get to your kid, who's maybe the second to last or the last kid to be picked up in aftercare, you're already stressed. You got to pick up your kid and then you get to go home and start all that homework. Maybe a better
Right.
approach is let the other parent pick them up after school. And after rush hour is done, you get to go have your time, you get your overnight, and you avoid, some of that rush, that stress for which really, yeah, we deal with it as parents all the time. But for your kid, that's not fun
Hmm.
for your kid. That's awful. But you have to explain to your client, take you out of the picture for a minute. What is best for your child? And how does
Hmm.
this 50-50 really work with your schedule? How do you make it work?
Yeah. And
Especially, especially if you have parents that don't talk to each other. How about that?
yeah, and that's one of the things, right? If you have true equal time sharing, 50-50, communication is key. And
Oh,
I
yeah.
have found so many people, a lot of the reasons they're getting divorced is because they don't really communicate with one another very well. So it
Hmm.
it it presents itself a challenge, and often I think the parents don't always consider, how does the child feel about this, and what's really best, for your child, particularly in a situation like that, with so much time in the car, and is there a way that you could make this better? Um, and I think often, everybody agrees. I just like you had said earlier, well, they start out with the thought, well, I want equal. I need it to be 50-50. And oftentimes it's like, well, I don't want them to have more, not a 60-40 or 55-45. We have to be equal. I want as much time. And it's like, well, how does that affect your child? And what are the logistics of that? And, I think some children, and I'm sure you've seen this, do fabulous with that and the parents, but some really struggle. And I think that, that can be often a time where they do come to the attorney's office and they're like, my child's really struggling with this schedule. They're not doing well in school. And, now they have a therapy because there's more stress and anxiety. Um, and, I want to look to change, our current schedule. And I think that is a valid reason, when it's exhibited in your child. And, but still it's going to be difficult to get that, to persuade the court, I believe.
Sure. And that brings us back to evidence, when we started as, prosecutors. And I remind clients all the time, just because you think it's right doesn't mean it's right. And if you're in a situation that's contested, We say contested as lawyers all the time, but, for the listeners, it's you don't agree. You can agree, and it doesn't matter how much money you pay your lawyers, you are not going to agree. Look, as lawyers, we can't force our clients to agree. I mean, that's a big problem. Can't do that. So if you can't agree and you're going to end up in court on this issue, let's talk about, is your evidence admissible? What kind of evidence do we have here? I think a lot of parents feel like their kids are struggling, and there's concrete evidence to show struggling. We've got academic school records. You've got standardized tests. You've got notes from the teachers. You've got your kids in with a tutor. You've got tutoring. Get your evidence together, form all of the information that you need. And then, if there's a therapy involved, maybe the psychologist, maybe they won't testify, because a lot of times they won't, for good reasons, I believe, confidentiality and, doctor-patient privilege. But you know what? They could provide you really important information that comes up in therapy that you can use in court, which demonstrates your child is struggling with this. These are some resources and tools that you can use to try to help them. And then, we always want to try to mitigate before you get to court and offer tools and options for clients, even in highly contested cases with parents that don't talk. There's tools out there for people to communicate, our Family Wizard and Talking Parents. And I know App Close is another one sponsored by, I think, Apple. All these communication apps, where you can download material and send it to the other parent if they won't, unfortunately, get on the phone and speak to you. Or my favorite is, why don't you encourage the other parent to go meet with the therapist, or go meet with the teacher, or go meet with the tutor? Don't go. Keep yourself out of it. Let them go and have a meeting themselves. Let them hear it directly from the source. Then it's not a he said, she said game anymore, right? Now it's not my wife. My ex-wife said it. She's having a problem. It's, wow, these are her grades. This is what the teacher said is a problem. People don't do that, though, Heather. I feel like it's, just fight, fight, fight. Well, stop for a minute. Let's look at the tools that we have available and see what you can do to help your kid before you get in front of the judge that may or may not care if your kid is struggling, according to you. I mean, I hate to say it that way, but it's true, right?
Yeah. And it's definitely, I agree with you 100% on the evidence. And that's why I framed it that way. So we have, if you're not doing well, let me see the school records. Have you spoken to the teacher? What do they have to say? What does the tutor say? Are they in therapy? I always encourage, whether or not, like you said, the therapist is going to testify, the child needs an outlet, and you need to hear maybe from the therapist what the child won't say to you, like what's going on, and find out, and what do they advise? Because, as parents, I think I can speak for most all parents. We're like, I know what to do, right? And, don't need to go over to ads this many times or whatever. But that may not be what they prescribe. It just may be, some other tools. So it's so important, because we, as in our firm and with my lawyers, I'm always telling, we're not going into he said, she said. We have to have evidence, and that means other witnesses and documentation, so that it is not perceived by the court as you just don't like your ex-husband,
Right.
your ex-wife, and that's why you're here. Because of course that gets portrayed often, and that happens. So it's so important. I think too often, I don't think our clients understand as much how valuable that information is, that can then the court, I find they do give a lot of deference when there is a mental health professional involved and they have given a recommendation, because they've seen the child once, because you have put the child in there, because you notice some problems, right? You're trying to address them and fix them. And if they truly have a recommendation or advice, that will be taken seriously, I would say, more often than maybe what your opinion is should happen if you're in a courtroom setting.
No, I would agree. I mean, I always say you wouldn't go, I forgot the saying I used to tell my kids, but you wouldn't go to an eye doctor to have your teeth checked, right? You're not going to go to the hospital if you have a legal issue. So if we're talking about a child struggling with mental health, the best person to testify is therapist or someone that has knowledge and background in the area of mental health. They don't necessarily need to be a forensic psychologist or have a PhD. I mean, a licensed clinical social worker is perfect. as long as they have experience and education and they've met with your kid and they know what your kid needs. That's what the court's going to want to hear. I mean, that's really the best evidence, right? When we think about what are we going to use, it's not going to be mom or dad says it, so therefore it's true.
Absolutely. And that's, I think one of the biggest hurdles for many clients, and just to understand that you need to take some of these steps first, because just because you call the lawyer and go in there now, of course I'm going to assume this, but we've both been in cases where the lawyer probably just did that and they didn't require your client, to do that work, and then they're not going to prevail and cost, time and money for everybody. And, if the child really was suffering, didn't do the necessary things to prove that. So it's
I would agree.
very important. Yeah.
Yeah.
It's
No, I would agree.
important.
I don't even think
Yeah.
it matters what area you're in, like what area of Florida you live in. It's
Oh,
just
yeah,
common
no.
sense, right?
It is, if you've practiced long enough. Like, I do think there are some, practitioners maybe who are newer and think, and I mean, I can still remember when I was a new attorney and just been like, oh, you hear that story from your client and you're just, overwhelmed. But then you're like, well, who's going to back you up? Who else is going to say that? Because that, is definitely what you need if you're going into court. And if your attorney is not, asking you to get that other witness or other evidence, if you're listening to this, we're just telling you. We're both telling you, you need to have it. So
Yeah, red
look
flag.
for more.
Red
Yeah,
flag. Get your evidence together.
absolutely.
No, it's true. And those
Absolutely.
apps are so good too, for parents that don't want to talk or can't talk, you go to the doctor, you upload the invoice, you send it to them on the app. You can check to see if they checked the message, you've given them proper notice. Same with like these teacher meetings. Sometimes they get changed last minute. Teachers have a lot going on. Their afternoons are filled with meetings, and some of them tutor after school for extra money, especially if you're a public school teacher. They need a little bit more of a hustle in the afternoon, to support themselves and their family. They might have to change, or maybe they have a doctor's appointment or something personal that came up. Get on the app, message the other parent, hey, the teacher conference got rescheduled. It's going to be on this day. Don't let them wait to show up to the school to find out it was canceled, because they're going to blame you, especially if you got the email before them. Share the news. It's not a
Yes,
big deal.
exactly. Don't play gotcha. It just doesn't fare well. Let them know. The apps are great. I completely agree. They can, even for a non-contentious case, it just can make it a very easy way to share information
Sure.
that you have a record of, right? When,
Mhm.
we're all busy and did I send this or did I not? It's just a great spot to communicate. And then when there is difficulty with that, it can really fill that gap so that it's not always maybe going to court or needing a parenting coordinator, because this is a tool, when used correctly, can make a big difference. I agree, for divorced parents.
For what, like $100 a year? I think our family
Yeah,
recently
I mean,
just went up to $199. I think they increased their prices, but $200 a year for that? Come on. Hey,
and I did an episode
oh, you
not
did?
that long ago with someone from our family wizard.
Oh,
The
I'll have to check it out.
technology that they have even added, it's pretty amazing. Again, for the price, yeah, Rebecca Para was who I had on. She's an attorney and who works for our family wizard, and she was able to explain all the things. And now they use AI to, if you are in the emails, to say that tone sounds a little harsh. Maybe you want to reword it. So it's now
Oh, wow.
actually helping you if you don't know, right? And it's called the tone meter. It actually,
Wow. I learned that
yeah,
today. That's cool.
I know. It's really cool. And so you can use it when maybe you're just not sure or you're in a rush. But of course, there's not always the tone and inflection in an email, obviously, that can change it. And then, of course, however somebody perceives it when they're reading. So they are integrating that AI just there's no record of that, right? So no one's going to look at it and go, oh, they ignored all of these tone meters that said this is aggressive, right?
Yeah.
It's just for you to, again, try to lessen if it sounds a little bit too angry or adversarial. in the language. So it's really impressive. And I think if people really want to use it and want to communicate better, it gives you that opportunity.
It's like your own little therapist, right? It's like
It
your
is. I know.
the devil and the angel, the scenario on the shoulder. Which one do you want to be today? That's really cool. I didn't know that. I'll have to tell my clients
And
about that.
And now they also have a phone call part so you can make your calls. And this can be really helpful. Actually, we have a case now where it's quite helpful, but
Mm.
they'll record them and transcribe them. And then also talking parents will
Mm.
record them. And in the transcript,
Mhm.
you just see like dad and mom talking, but we got the recording and it's actually dad's girlfriend talking.
Oh, wow.
And so now that creates a whole nother dynamic to see
Sure.
maybe why it wasn't well received.
Oh,
So
yeah, for
anyway,
sure.
it's fascinating stuff. And, we'll put those links in the show notes, listeners, just so if you need those resources. And they can also be very helpful, if you are seeking a modification because of whatever reasons, and you just want to make sure you can show you are trying to communicate and you are sharing information on what's going on. That's a great spot to do it because it's there permanently.
It's recorded. Nobody can
Uh,
erase it. Nobody can
They can't
edit it. I
erase
mean,
it.
I was just thinking about this the other day with the whole recording and being on an app and how important it is. You've got your phone. Let's say you're texting and I'm just talking iPhone because that's what I have. I don't know a lot about Androids, but let's say you make a typo or something, you can hit edit, right? And then
Mm.
you can go down to the end and hit edit. And you can erase like 15 messages that are in your text thread if you don't want them on your messages anymore. And then when someone wants your records, all those messages are gone. Well, that's not helpful. Maybe it is if you're the proponent and you want the messages trashed. But if you're on the receiving end and now you can show potentially, going back to evidence, right, that it's all been redacted and changed and deleted. Now, judge, none of this is admissible because she's changed all of her text message thread. Not happening with an app. It's all there. You can't
Yeah,
unsend it, can't edit it. There.
absolutely. And it's true. Yeah, with that edit function, even after it's been sent and read, you can go in and edit it.
Yeah.
Yeah. So yeah, it's the reliability there is not as well. But if you screenshot yours, I guess, but like, oh my God, how time consuming, right? You're always
Oh,
screenshotting things, then you're gonna get consumed in that. So it's just the app for so many reasons is the better way to go.
oh yeah. I'm a big proponent for sure.
And all right, so now I want to talk about when, we're looking at a modification and one of the biggest modifications, I mean, not as frequent, but is relocating, right? Because that
Yes.
is a big, substantial case that there can be very valid reasons for. And,
Sure.
I'd love for you to share, you know, what that looks like and what our listeners should be thinking about if they want to relocate, if they
Mhm.
have a new job offer, and just share with them on that.
No, it's a good subject. I actually got 3 of these calls this week and I was like, it must be in the air. And then you wanted to talk about it. I was like, okay. So the first thing, whenever you're talking about relocation, for me as an attorney, I always point to the law to start out with. And most people don't want to necessarily be schooled, on what's going on. But, we got to start with the law because if you're not following the law, I'm not filing your case, number one. Somebody else might, but I'm not. And number two, you need to know exactly what you're dealing with. So we refer to the statute, which is Florida Statute 61.13001. And that really hasn't changed, just for everyone that's listening. A lot of changes, but the relocation statute has not been changed. So if you're going to relocate, first of all, we have to talk about, is this substantial and material change? And is your relocation in the best interest of your children? That's where we start. So and if you're moving for a job, you got a substantial and material change. So check that box. There you go. Now we have to get to the analysis that we talked about earlier about, is it in the best interest of your children? So I get this question a lot, is the job offer, how do we show our job offer? And I'm just using a job offer, an increased job opportunity or increased salary. That's kind of your typical, I feel like, example, but there's plenty of others. But for conversation purposes, how does that affect your kid? Well, does it make you put yourself in a better position financially? What will help you become a better, more involved, more consistent, sometimes just time itself, right? Parent. Usually the answer is yes, and it will benefit your children. Maybe it's better schools. There's a great way to prove
Mhm.
that it's a best interest of the children's standard is being met. Greater schools. Maybe you have your kids in private school and you can't afford to continue to put them in private school, but this new opportunity is going to be able to allow you to utilize the public school system, which might be even better than the private schools in that area. And you're not necessarily going to have to pay for education for your children. So that's really important. But then we go to the statute, right? And we talk about all the factors. Our statute in Florida is written where you can literally make a list. We have specific statutory factors that the court is required under the statute, right? The court's going
Mhm.
to follow the law. They have to follow the statute. So we can start directly with what is in the best interest of our children. And people say, what does that mean, Lisa? How do we get that, right? Well, we have A, B, C, D. We go all the way down the alphabet, and now we end at letter T. Maybe next year we'll get to Z. I don't know, right? And that's how you determine whether it's in the best interest of your children. So nobody likes homework. I didn't like it growing up. I don't like giving it out as an attorney, but I do give out this statute, and I have another spreadsheet with check marks. Does this
Mhm.
statute apply to you? Does this factor apply? First of all, where are you moving? Let's talk about that. Where are you going to be living when you get there? What is your living situation going to look like? If you have 3 children in a 2-bedroom, 2-bath apartment down here and you're struggling to make ends meet, and now you're going to be living in maybe a 3-2 in a better neighborhood and better schools, you know, physically, your roof over your head, where are you going to be living? Let's talk about that.
Mhm.
You need a plan. How about that part? You got to have a plan. We can't just flip a coin and say, let's see if the judge allows it. No. First of all, in our petition, it's very specific. You have to outline all the factors and why you believe it's in the best interest and has to be sworn to, right, Heather? You have to
Yep.
swear to it, stating that this is in fact true. And then they get an opportunity, the other parent, to rebut that and find out, well, are these factors true or not? They get to file a response. So the geographic location is outside of a 50-mile radius, 50-mile radius of where you're currently residing. If it's under that, you're not required to file a petition to relocate, but you may need to address your parenting plan because if you're 49.9 miles, I had that case a couple weeks ago, which I
Oh,
laugh
wow.
at, literally, and then we had to do Google Maps, and then we did Waze, we did maps through Waze, and then we did as the bird's eye, the crow flies. We did it all, and just below the threshold. But I said,
Wow.
you'll probably need to modify your parenting plan because the time might not be required under the statute, but what about your kids? How are you going to
Yeah.
do the schedule with this much distance between you and the other parent? Especially if it's a 50-50 schedule, it's not practical, So sometimes you have to, maybe not modify in court, but maybe agree if you can to change the schedule that fits, where your new location is. But one of the really important things about the factors is I think the legislature really understood when they made some modifications in the last session as to what, as practitioners, as attorneys, what we need to prove, which helps us
Mhm.
guide our clients in saying, well, what evidence do you have and how can this affect you? And then, I do want to focus for just a minute. I know you already did a whole episode regarding, Grayson's Law and everything related to that. But in letter M, I actually have had this case multiple times where the threshold of domestic violence has now been changed as of July 1st, 2023. And they've changed it and they've added the bold language in the statute, which applies or evidence that a person has or has had reasonable cause to believe that he or she or his or her minor child are in imminent danger of becoming victims of an act of domestic violence. So that's really important. That's been added. And I think for anyone that's struggling with any type of domestic violence in their relationship, this factor is really important. And you don't have to literally be the victim, whether it's physical or emotional abuse. At this point, if you have reason to believe that you will or your child will, you or your child, not both, you or
Mm.
your child, then that will meet the statutory threshold for potentially a modification. And it definitely is going to affect a relocation case. And I don't like to talk about it initially with clients, but I think when you've dealt with domestic violence as a prosecutor before, there's certain things that you hear from a client while they're talking. There's certain mannerisms. There's certain, I think, ways they refer to behavior. A lot of defense mechanisms we can see from a phone call, even from the person's voice, that, helps me see, okay, this may be an issue, even if they don't tell me. This may be an identified issue that I have to address, one way or another. So I do want to point that out. I think it falls into relocation and modification, and it's so important for everyone that's ever been a victim or feels they may be a victim of domestic violence to consider.
Agreed. And that, and even before, that particular language and part of it changed, it's always something, and you and I have that same sense because of experience. You just dig a little deeper because you're hearing things that sound like that might be an issue in the marriage, even if the client doesn't come right out and say it. And I find I know I've said this more than once to many clients as have my attorneys, is if this is going on, whether it's the original divorce, or paternity, whatever it is, if this is a situation that's going on, we do need to bring it up. And it's not like, you can't wait till later on in the proceedings and say, oh, I want to address this. I said, you'll lose so much credibility. And if it is in fact an issue, it's in your best interest, as well as your children's, to, even if you are scared and you're nervous, it's going to make them, really angry. There's some of the conversations we've had over the years. It's very important because it's, your safety and health, are an issue. And I do believe that it's really important. And now, and again, there are our thresholds of evidence, and it may be something a little bit more difficult to prove. However, it really is important to make that record. And if those things do exist, to bring it to light, and, let the court determine whether or not they think it, is relevant or not.
Right. And I also think, to add to that, Heather, that a lot of people think, well, I have to get a restraining order. I need to file a petition for an injunction, which we call a restraining order. It doesn't always have to get to that level where you have the burden to establish that you have been or will be a victim of domestic violence to the point that you're getting a restraining order. This is an issue in family court. We're not in domestic violence court, which is a whole different issue. We're in family court, and it's an important factor when it comes to modifications, when it comes to the best interest of the child. All of that is relevant. So I like to address that issue because I think a lot of people just assume, well, I have to get a restraining order. And you might not have enough evidence to get a restraining order, but you do have enough evidence to modify your existing parenting plan or your settlement agreement if domestic violence does become an issue. That's really important to note.
And I appreciate that you highlighted that, because that was another one of the topics I wanted to talk about is, things like turmoil in the co-parenting relationship. And, when is that a reason for modification?
Such a good question. So we have so many cases on what's the standard, to prove for a modification. And I know, at least in South Florida, we're governed by the 4th District Court of Appeal, and they've, I think, written 10 opinions in the last probably, 7 or 8 months on this issue. And I print the cases, Heather, and I highlight the ruling from the court, and I give them to my clients when they come in with this issue. At least down in South Florida, and I don't want to speak specifically for other regions because I don't necessarily know your district court's opinions, up in Jacksonville or anywhere besides South Florida. But the point is, not getting along and not being able to communicate is not a reason to modify. It's not. And not being able to co-parent is not a reason to modify. Period. End of story. There is really no exceptions to that. You need to be able to show a substantial and material change that does not affect your ability or the other parent's ability to get along with you and make decisions. It's just not a ground. Does it create stress? Absolutely. Does it create extra emotional turmoil on your relationship? Absolutely. But that's where we go to other collateral resources. Get yourself in some therapy. Join maybe a support group. Maybe you need to get on an app like we talked about and use that AI function for the tone meter. There's plenty of resources out there, but you're not going to get a modification if you can't get along. And
Mhm.
probably, I know this sounds silly to say out loud, but you probably know what I'm going to say. There's a reason that you're not together anymore. And it probably has something to do with the fact that you guys can't get along. So we're not modifying a court order because of that now either.
That's right. And that you summed it up perfectly, and it'll be good for our listeners to hear it. And usually also, it's not a new change, right? You probably weren't getting along originally either, when the divorce happened.
Right.
But okay, now I do want to talk because the time is going so quickly, but I have a few more things that are really important. One of them being, issues of mental health or addiction, with a parent. And let's just talk about that and as a basis to go in and seek a modification on the time sharing.
Well, first of all, any type of issue related to substance abuse or a mental health issue is a problem, number one. And I think it's a problem whether you're getting help or you're not getting help. And I'm not saying that because I would discourage anybody from getting help with a substance abuse or a mental health issue. That's not what I'm saying. What I'm saying is if you can show that that issue was not present at the time you entered into the agreement, or it did not affect your children the way it is affecting your children now, then I believe in most cases you will be able to meet the threshold of a substantial and material change. But don't forget, it has to affect your children. And whatever change you're requesting, whether it's a modification of time sharing, whether it's, maybe a modification of parental responsibility, who's going to be the major decision maker when it comes to children's issues. Maybe you want ultimate versus you want to take away shared and you want ultimate decision making, or in some cases, you can establish sole parental decision making. Then if it's affecting your children and the change you're requesting, you can establish that it will be in the best interest of the children to have the court grant that change, then it's important and it's going to meet the threshold for a modification. I had a case, it's been a case for a very long time. It keeps coming back for different forms of modification, but I wanted to just highlight it for a minute because I think it goes right to this issue when we talk about modification and relocation and any type of substance abuse. The court is no longer required under the new statute to give a parent a step-up schedule, meaning in the event that you maybe are suffering from a substance abuse problem and your time sharing has been, I don't want to say suspended, but maybe it's been minimized in some way and you've lost 50% of the time sharing, a court no longer has to tell you what you have to do in order to restore your time sharing. And I have this in a case, and what's important about it is, well, it's frustrating on multiple levels, but in this particular case, the person was getting treatment at the time the order was entered, the parent that had the problem. They were getting treatment. They dropped out of treatment and they relapsed. And it was a very short period of time. And during the time that they were okay, I don't want to say any long period of sobriety, but they weren't using the way they were before when the order was entered, they then filed for a modification, but then relapsed again while the case was pending. So multiple hearings, you can imagine, and we just ended up getting back to the same place, multiple mediations, because I really didn't want my client to keep litigating. There was a lot of fees involved. Really what it came down to is what is best for this little kid. He was 3 when they got divorced, and now I think he's almost 7 now. He's in second grade.
Mm.
So what's best for this child? So I'm not going to ever stop a parent from fighting for their rights or wanting to be able to establish a relationship with their child. But if substance abuse is an issue, and in this case it was, you got to get help and you have to be able to establish a long period of sobriety. This isn't like I did great for a month, so I passed my hair follicle for 6 months, so now I'm good to go. Let's just get back to normal here and get back to the normal schedule. That's not thinking about the child. That's thinking about the parent themselves. So
Mhm.
it's definitely a ground. And then in regards to mental health issues, I think it falls under the same category. A lot of times I think people suffer from different types of mental health issues as maybe they get older or as different chapters of their life unravel. And sometimes it's just it's not even severe. Sometimes it's, mild cases of depression or anxiety just from getting through a divorce. Let's talk about that. That's stressful in itself.
Yeah,
And
indeed.
then,
Mhm.
and then getting back on your feet and starting a new chapter. I mean, someone that's been married for 25 years and now they're single with little kids, or even teenage kids that are extremely demanding, right? Then they're going to suffer a little bit, But I think the best thing to do in that case is maybe not necessarily file for a modification and try to change things, but use the tools that are available to help you in that stage of life get to be where you need to be, one way or another.
Mhm. Absolutely. And again, which you have reiterated throughout the show, but it's important is how is this affecting the children? And that, really trying to figure that out because we've both had the cases where they were severely affected and changes, were really recommended and that's usually what the result ends up being is it needed to be a change for their best interest. And so, that's really where, yes, there's a lot of other pieces to the puzzle, a lot of other evidence, but that is where you need to, I think, for our clients and listeners, think about that, right? Like, is this change going to be better for them, at least from what you think? And then out of that, then you go and seek some advice from your attorney because that is the key. And that's what the courts are gonna, they can't only make the decision on that. But if you can show a way that they've met all the others, they really do want to make sure that the children are, in the best situation and that what they're doing, is going to improve their situation.
I would agree.
Well, this has been a great show, and we're gonna have to have you on again and go through more topics. But I really appreciate you being here, and I know that you have been practicing for many years, and have represent men and women in your family law practice. But we represent women only. The show is Women Winning Divorce, and I would love if you would share with our listeners what you've learned about divorce and representing women throughout your career.
Great question. So, one of the things I've noticed over the years is I think women are sometimes overlooked in the justice system because we are supposed to be a strong rock for ourselves, for our kids, for our spouses, maybe for a new partner that's a new relationship. And I think what my main goal is when I have female clients is that look yourself in the mirror and be proud of what you've done. It's not easy to be a mom, no matter what. And even if you don't have children, it's not easy all the time to be the best wife, the perfect wife, or even, in the world of being a single woman, it's not so much. But I think with a really strong background, an extremely important concept of self-worth, and then a dedicated practice to yourself that you're going to always try your best to become a better person than you were the day before. That's all we can do. And I personally think women are smarter anyway, just because I look at statistics. My husband and I laugh about that all the time, but I have 2 girls, so I'm okay saying that. I come from a family of women as well. I have 2 sisters, but it's important to know that there's a lot of weight on our shoulders. And I think what's helped me just on a personal level, to grow my practice and be as much of a present mom, as I can be. I can't do everything and I can't be there for every little thing that's super important for my kids. But what's most important is to be the best that you can be every day and know that you can't always do more, but to be happy and confident with yourself that you were there and you showed up and you did your best. And I think that's really, what I love about representing women and doing what I do in family law, because I think it's easy for women to be taken advantage of in different situations. And sometimes literally, and I tell my little girls this, sometimes it's literally as easy as putting 2 feet on the ground, putting your hands by your side and looking somebody in the eye, straight in their eye, and giving them a smile and say, thank you. Something as small as that, or you really made me feel special today. Just a small thing, that eye contact and just standing on your own 2 feet, it's so important. And I think it's really helpful and empowering to women in general.
Thank you so much. I've really enjoyed this show with you today. Where can the listeners find out more about you and your resources? Because you have a podcast too, if I'm not mistaken.
I do, yes. We haven't recorded in a little while, but we're working on it. That's a conversation for another day. But we have, I think, 40 episodes up. But it's been a process trying to juggle everything. So my law offices, I have a main office in Fort Lauderdale, and that number is 954-761-2522. And then I have a smaller office in Boca, but all my calls are routed through that number. So that's the number one way to get a hold of me. And then I have a website, which is www.honickmanlaw.com. I won't bother spelling it. I know you'll probably link up all the website information on the show. And then I'm also on Instagram and I'm on Facebook. Facebook is the law offices of Alyssa D. Honickman. And then on Instagram, it's _Alyssa_Honickman that you can find me. And my podcast, my other podcast is called Confident Chaos with 2 C's. And it's myself and my good friend, Dr. Tiffany, who's a cardiologist. And it's a fun podcast. We're on Apple. We're on, oh my gosh, pretty much all the
Spotify. I'm sure Spotify.
Yeah,
yes. And all the other
yes. Yeah, Spotify. And you put me on the spot, so I can't remember all the things, but
that's okay. But they'll find you. Okay. They'll find you. Confidence Chaos, right?
Yes.
Well, Alyssa, thank you so much. Like, this has been a real pleasure. You are a wealth of information, and we will make sure all of those links, listeners, are in the show notes so that if you want to reach out and connect with Alyssa and her firm, you're in that area, we will make sure you can easily find her. And thank you again for giving us your time and all your great advice today.
You got it. Thanks for having me on. I appreciate it.
Absolutely. We have reached the end of our show. And listeners, if you or someone you know is going through divorce or is thinking about a divorce, please reach out to us at FloridaWomen'sLawGroup.com or join our Facebook group, Women Winning Divorce. Links will be in the episode description. And as always, we would love your feedback. And if you're so inclined, a 5-star review so others can find our show. Thank you for listening.
Are you facing the challenges of divorce and feeling overwhelmed? Introducing Divorce 101, your essential online course designed to empower you through the divorce process. I'm Heather Quick, attorney and CEO at Florida Women's Law Group. Gain confidence and clarity with expert guidance on legalities, financial considerations, and your emotional well-being. We believe in empowering you to navigate this journey with strength and knowledge. Enroll in Divorce 101 today and take control of your future. As a valued podcast listener, you will get $100 off the course. So please see the show notes for the promo code and the link. You can also find out more at FloridaWomen'sLawGroup.com or always call us at 904-567-0121. Divorce for women, by women. Thank you for joining me for this episode of Women Winning Divorce. My goal is to elevate your life and the way you are thinking so that you are best equipped to win at life. If you enjoy the show, please subscribe so you automatically get my new shows every week. And I would love to hear from you personally. Come join the conversation on social and join our Facebook group, Women Winning Divorce. We welcome your comments and suggestions. We want to bring you content that helps move your life forward. Women Winning Divorce is the place for an elevated conversation on how women can thrive during times of adversity in order to live their best life.